Okay, we've talked very briefly about lawyers acting as mediators. Now let's talk about them representing parties at mediation. You obviously will have your obligations to your client, but you will also equally have obligations to opposing parties and their counsel or solicitors. The main obligations that you will have are your obligation of confidentiality and your duty to act honestly, as well as your duty not to mislead your opponent or obviously to lie or act dishonestly. So this touches on confidentiality. I'm not going to read it all out to you, but Rule 3 of the Professional Conduct Rules. And your duties to your clients and opposing parties are set out in Rules 8, 9, 12, 13, 18 and 28 of the Professional Conduct Rules, and your duty of honesty is set out in Rule 30, and you'll see them set out in the paper, so I won't dwell on them. The main problem that people come up with or come up against is if you learn information in the course of a mediation, or you are told something that you suspected might have been the case but it confirms a view that you've held, what can you do with that? Can you use that information in the trial or interlocutory proceedings which might follow on from a mediation? So the common law position, which most of you will be familiar with, was set out in Field and Commissioner for Railways in 1957, and the High Court decided that case, and it's reported at volume 99 of the Commonwealth Law Reports. What the court said there was that as a matter of policy, the law excludes from evidence admissions by words or conduct made by parties in the course of negotiations to settle litigation. The purpose is to enable parties engaged in an attempt to compromise litigation to communicate freely and without embarrassment that communications may be put into evidence. So basically, the policy behind, if you like, without prejudice communications is to enable parties to try as best they can to settle litigation without the prospect that what they say to each other may suddenly appear before the court. So you then have the question, is the confidentiality which arises out of mediation the same as what you would get under without prejudice privilege? On one view, and probably correctly, mediation as a process requires a greater degree of frankness and openness than would normal without prejudice communications. The whole purpose of mediation is to try and get the parties to a point where they can agree on a resolution of the matter, and to do that in a way that it is facilitated so that parties can come to that point. There needs to be a degree of openness and frankness. The other factor is, of course, that not all communications will be covered by without prejudice privilege. You need to have an actual dispute, that's the first point, or alternatively a dispute which is where litigation has commenced or is clearly contemplated, and I've referred to the Glengarland case in the paper about that. What if you have a dispute which has arisen but the parties aren't quite at the litigation stage and they decide that they want to have negotiations? Are those negotiations going to be covered by without prejudice privilege? Perhaps not is the answer to that question. So you then have obviously situations where parties will want to mediate before litigation has commenced, and what obligation will there be to keep that information which may have been learned confidential? First of all, the first point of call for every mediation will be your mediation agreement. It may make communications without prejudice expressly in the agreement. It may also require parties not to subpoena or join the mediator. These are some of the protections that you will have. So you will also have then statutory confidentiality provisions. Section 24A of the Supreme Court Act and Rule 5007 of the Supreme Court Rules are common examples of where the courts order mediation. And so what the court says is, look, we've ordered this mediation, so anything which is communicated as a result of that mediation is to remain confidential. But there are situations where you've started a proceeding and you haven't yet had the court order mediation. It may be very early days and your client wants to mediate. Well, arguably then, those provisions won't apply because there is no active court order. So what then happens? Well, Section 131 of the Evidence Act, which was enacted in 2008, sets out the position that you will have to deal with there. And it, again, will exclude communications, but it's in slightly different terms to Section 24A and Rule 50. So I just pointed out because depending on the circumstances of your mediation, you may be governed by one and not the others, and so you'll need to consider that. Another situation where you may be required to make disclosures is if there is a serious crime or fraud being committed, or something which is putting public safety or a person's safety at risk. There's situations where you may be required to make a disclosure. So what use can you make of information then if you obtain it in the course of a mediation? Well, the case of AWA and Daniels dealt with this situation, and that was a case which some of you may remember was where the plaintiff had sued the defendants for damages for alleged breach of duty to audit properly. The case ran for 12 days before Chief Justice Rogers in the New South Wales Supreme Court, and it was then referred to mediation. At the mediation, there was some dispute over what the clause requiring parties, there was a clause and it required that the parties warrant that there was someone there who had authority to settle the dispute. The plaintiff's solicitors didn't have instructions to consent to the inclusion of that clause within the mediation agreement. The defendant's solicitors said at the mediation, look, we'll accept an oral statement from you to that effect, and we won't require inclusion of that clause in the mediation agreement. The plaintiff's solicitors then made an oral statement and disclosed certain matters in the course of doing so, and they said that the statement is made without prejudice and is made on a confidential basis. What the defendant said is, look, the matters that came out of that statement simply confirmed a view that I already held about this matter. It confirmed some facts that I thought to be the case but wasn't sure. The mediation didn't resolve, and the defendant's solicitors then issued notices to produce various documents. And the plaintiff issued a notice of motion seeking to set it aside. What the plaintiff argued was that it was an abusive process because calling for documents which only became known to a defendant in the course of a mediation on a confidential and without prejudice basis was not appropriate. They argued that the mediation was analogous to without prejudice discussions, but the nature of the procedure demanded a greater degree of frankness. Anything that would hamper the requirement for frankness would hinder the mediation process. The defendants, on the other hand, submitted that there had been no attempt to breach confidentiality, that what had been conveyed to them in the mediation just simply confirmed matters which they knew to be the case or believed to be the case, and they weren't trying to give evidence of what actually transpired at the mediation. What they were trying to do was they were trying to admit documents which would seek to prove the facts set out in those communications, but they weren't seeking to give evidence of the communications themselves. So what they said was that there was no basis for setting aside the notices to produce. On that interlocutory application, which was heard by Justice Rolfe, he referred to the competing arguments and held that a party could not rely on an admission in settlement negotiations, but the notices to produce did not seek to prove directly or indirectly what was said at the mediation. Therefore, the notices to produce were not set aside. So to pause there, if what you are doing is not seeking to prove precisely what was communicated in the course of the mediation, but rather to prove an underlying fact, you can do that by secondary evidence, by documents or other witnesses. That's permissible. Chief Justice Rogers then when the matter came back before him, considered the same issue when the documents which had been produced under the notice to produce were sought to be tendered. He then had to consider, well, can they be tendered? And he said that in situations where the fact only became known to the other side only because of a statement made at mediation and would not ordinarily have come to the knowledge of the other side, he would hesitate long before concluding that the objective evidence was admissible. This is by way of obiter. He referred to the need for frank disclosure and that the parties should be able to reveal matters without apprehension of disclosure. However, he agreed with the conclusion reached by Justice Rolfe because, in that case, the defendant's representative had demonstrated that he was alive to the possibility of the existence of this material before mediation. So if you're acting for someone who finds out information in the course of a mediation and you are then challenged later on about having it not being admissible, you'll need to be able to show that there was some basis upon which they believed or knew or had a basis for knowledge of this material before the mediation. So that approach has been followed in Williamson and Smith and in 7, 8, 9, 10 and Westpac. And Justice McDougall in the last case says that, and this is interesting, he says there are insuperable problems with any attempt to extend the common law privilege from statements or documents to information contained within them. So the common law privilege applies to statements and documents, but it won't apply to the information you learn from those particular statements or documents. The practical effect, if it was to apply to information, would be to discourage early mediation. Parties would feel a need to prepare cases fully, and there would be substantial expense and entrenchment of attitudes at an early stage. So they were his observations. So in short, I think the answer is you can't seek to admit evidence which is of direct nature relating to what was said or done at a mediation. You couldn't, for instance, say, Mr. Smith said this at the mediation. That would be inadmissible. But if Mr. Smith has told you about an agreement and you've then gone away and been able to find that agreement some other way, you may be able to tender that agreement. So that's how that all works. So Rule 18 deals with lies and untruths, and Section 18 and 21 of the Civil Procedure Act 2010 will also cover those types of matters. So you'll need to be aware of them. Basically, what the Civil Procedure Act will do is there will be an overarching obligation on parties to act honestly. There will be an overarching obligation not to mislead or deceive other parties. That obligation will apply to the parties to the proceeding, but it will also apply to the solicitors. And so, in addition to the professional conduct rules, they'll also have to be aware of what these overarching obligations are. The sting that comes with those obligations is that the court will, if they are breached, have the ability to make orders as it sees fit about the proceedings. So, for instance, costs orders, but it can also take a view about the substantive matters held in the proceeding, and that may in fact impact upon them. So the final matter I'm just going to touch on before we look at the problem, and this is a matter which people often ask about, is, well, how much pressure can you put on your client in a mediation to settle? And the short answer to that is, look, you can put quite a lot of pressure on your client to settle. You can persuade a client, you can use reasoned argument, but you can't use improper means. You can't use undue pressure or inducements, and that's Harvey and Phillips. And Harvey and Phillips was a case in the High Court where that type of issue was considered. So obviously each of these cases will turn on their facts, but just to give you an example of a couple of the types of cases, I'll take you through Harvey and Phillips. It was a personal injury action, and the matter had been stood down on the day of the hearing. Senior counsel had recommended that the matter be compromised and had said, look, if the client won't take my advice, I'll have to return the brief to you. And he put the brief down and he went back to his chambers. And there's questions, well, is that too much pressure on the client to settle? The client's going to get a pretty clear message that senior counsel wants them to settle, and if the client isn't going to, well, that seems to be a reasonable amount of pressure. What then happened was the client accepted the offer and consent orders were made, and she later turned around and said, well, look, I didn't actually give proper consent to these orders. What the High Court said is, well, no, you did, and a solicitor can put quite a level of pressure on a client to settle. It can't use improper means. It can use reasoned argument, and in fact it was okay for senior counsel to put his brief down and say, well, I'm going back to chambers. Another case of this type is in the marriage of Anderson, and that was a property dispute where consent orders were made, and the husband said he'd been induced by counsel, and because the counsel had announced that consent orders had been made to the court, and the husband was present but he didn't object. So in that case, the court said, well, no, you hadn't been induced. You were present in court, you heard the orders being announced and you didn't do anything. So you weren't induced, and that's fine. Shahata and Hussein is another case which is referred to in the paper. That was one where the solicitor was alleged to have threatened a client by advising that he would lose and would have to pay costs. There was a high probability in any event in that case that the client would have to pay costs if the proceeding was unsuccessful. The defendant instructed the solicitor to compromise, and the court said, well, simply advising or the allegation that the solicitor had threatened the client by advising that he would lose and have to pay costs was not something that could be seen as improper or undue inducement or threat to the client. So the compromise was okay. So, I think that's the end. I just want to say quickly, what can you do practically if you are dealing with mediations and clients? First point, mediations are inherently stressful for everyone involved, be it the parties or the solicitors, in particular the parties. And also this will be flavoured too by the type of dispute you have. If you have a family dispute or a dispute where the parties have a personal relationship, emotions are going to run high and the level of stress can be incredibly high. Make sure that the client feels safe. If you are dealing with a family dispute or a dispute where you have a vulnerable party, make sure that they're comfortable with where the mediation's being held. Do you need security present? I had a mediation earlier in the year where one of the parties attacked the other party physically. So you do have situations where parties can be feel physically unsafe. So you need to make sure that the mediation place is suitable. Avoid long mediations if possible. I think a lot of mediators nowadays, while they want parties to sign up to an agreement and not walk away, I think they're open and alive to the fact that parties need to have breaks, they need to have time to eat, they need to not have mediations run too long. So encourage your clients to have breaks if they need them, and also to be able to contact people or have support people with them if they need that as well. At the end of the day, your obligation is to ensure that your client makes an informed decision about what they want to do at a mediation. And so you will have to be very aware of that and be conscious that they may not be able to make that informed decision if they're feeling tired or in a stressed situation. And for them to understand the settlement and what rights they may be foregoing, you'll need to be very cognizant of the fact that there are other factors which may play upon them. Just finally, I'll mention section 3.4.13 of the Legal Profession Act, which tells solicitors what their obligations are with respect to costs at a mediation or settlement, and I think you're probably all aware of that. So they're the main substantive matters I was going to talk to you about. Then I was going to go through the problem that you should have, which is an ethics case problem dealing with mediation. So I'll just give everyone a minute or two to have a look at that. Okay, as most people had a chance to have a look at that. Okay. The best way to do this is with audience participation, but if I don't get any, we'll just plough on. But the first question is, what ethical issues does receipt of the Insurers Council's brief raise? Will you read the brief? Everyone in the room will have come across situations where perhaps a document is disclosed inadvertently on discovery, or you may in fact have had this situation arise where a brief's come back to your firm and it's from the opposing counsel and you wonder, well, should I or shouldn't I read the brief? So does anyone have any views about what they think is the correct approach to take? And it doesn't matter, there's no right or wrong. I'm just interested to see what people generally think. No volunteers? Well, let's start by assuming that the brief contains privileged material. Does that help anyone?
It would depend on whether you actually read some of it before you become aware of something.
Okay, so the answer is it would depend on whether you read it before you realise it's not intended for you. That's right, and probably when you read it, you will realise that it is not intended for you. If you don't read it and you get it, what do you do with it? Do you sit it on your desk and think, oh, what do I do with this? Or do you straight away send it back to the barrister who it's come from?
I'll be sending it straight back.
Okay, Michael thinks we'd send it straight back. Does anyone else have a view? What about your obligation to act in the best interests of your client? Your client's best interests may in fact say that it would be good for you to read this brief because it's going to tell you information which might help your client. So you have a duty under Rule 12.1 to advance and protect your client's interests. So to discharge that duty, then it would be a good idea to read the brief perhaps.
That's why I'm saying if you actually read some of it, then and it was in your client's interest, then you would use it. You might feel obliged to use it.
Might feel
but
obliged
if you
to
have
use it.
read it, you choose to return it as
Should you send it to your client without reading it? These are the types of issues that you might have to think about.
What about your obligation to the court? Where does that stand in relation to your obligation to your client?
Well, your obligation to the court is paramount always. So it trumps every other obligation. So in this case, it's not so much an obligation to the court because you're not appearing before court, and we don't even know whether proceedings have been issued. Maybe, well, in this case they have been, but in some circumstances where you get a brief, proceedings may not have even been issued. So I think you've got to consider, well, what is the obligation that you would have when you get the material? If you read it, then privilege would be destroyed in the material, obviously, from the other perspective. And that's one view. Or alternatively, another view is that privilege wouldn't be lost because parties should not be able to benefit from conduct which reflects a misuse of their obligations to the court and rules of discovery and the like. If we were dealing with a criminal law situation, you'd have a general duty, for instance, if this was to come before the court, for the court to exclude improperly obtained evidence. What we have coming out of the Evidence Act is a general discretion to exclude evidence if its probative value substantially is outweighed by the danger that the evidence might be unfairly prejudicial or may be misleading or confusing. So arguably, it's not misleading or confusing, this evidence, and query whether its probative value would be substantially outweighed by the danger that the evidence might be unfairly prejudicial. However, if you read the brief, what you do with the information will depend to some extent, but in this case, the solicitor now knows that the life expectancy is very probably not sound, and he wants to settle at the mediation. Should he tell the other side that the evidence upon which it is based is no longer sound? Well, if you tell the insurer about the cancer facts, then understandably the insurer is probably not going to want to settle, or alternatively they're not going to want to settle for the same high level that they would. So there is a real tension there. You don't want to tell because your best interests of your client dictate that you will get a better settlement for your client if you don't tell. but you probably, at the end of the day, I think I agree with Michael's view that you send the brief straight back. You have a duty of confidentiality, and what the court will do in situations like this is they will say that you have a duty to act honestly and fairly in your client's best interests, of course, but you must also take steps to correct false statements unknowingly made to the opponent. So if a statement is made to you which is unknowingly false, or you've been given a brief in error, you should, I think, send it straight back without reading it. That's the view. Now, there is a Tasmanian case on this, which I'll find, but in any event, we'll keep going. Assume that the brief contains instructions to counsel to the effect that the counsel's solicitor considers Peter's claim to be strong. Well, I think we've basically covered that. It may be in acting for your client, in your client's best interest, that you feel that there is some form of obligation not to tell the other side's solicitor because you'll get a better settlement for your client. But by continuing to rely on the report to support your client's claim, after learning of the cancer facts, if I can call them that, it may be seen as an intentional deception of your opponent. So you don't want that to be said against you either. Okay, now let's move to question 3. Assume that at the mediation, Peter instructs you to discuss the schedule of damages, which contains statements about the cost of future care and talks about being based on his needs for the next 27 years. What should you tell the insurer's solicitor? You know that that isn't correct, and Peter's telling you to do it. Does anyone have a view? No?
About the duty to disclose.
Yes. And
because you have an obligation to the other side of the court.
yes, and that's right. You would talk to your client, and you would try and convince your client that it is appropriate to disclose.
As you said before, you're not the mere mouthpiece of your
Client, exactly. As I've said too, if you tell the insurer about these facts, then the insurer may not agree to a compromise. But if you don't tell the insurer, then you're arguably making some form of representation that the facts that you do tell them are the correct facts. So you have to be very careful. By continuing to rely on the report in aid of supporting Peter's claim, after learning of the cancer facts, then I consider that you would be intentionally deceiving the other side, and that would not be appropriate.
Anna, if your client absolutely insists, do not reveal it, it's just not going to happen, you'd have to withdraw. That's
right. I think the only answer is if your client instructs you to do something and it is contrary to your professional conduct, ethical obligations, then I think your only thing in that situation is to withdraw. Obviously, you have to be very careful how you do that, because you also are in the course of a mediation, and you can't be seen to be doing something that's contrary to your client's best interest, which may be, i.e. flag to the other side that there is some mistake in this material. So you would need to perhaps get the mediator on side, get instructions from your client about what you can tell the mediator, and then terminate the mediation on terms that the other side doesn't appreciate the problem. Yes, and I've referred to that, the last slide, I think, before we broke, referred to the Mullins case. And that this problem is actually modelled on that case, but it's a useful decision if anyone's interested. It's referred to in the paper, Legal Services Commissioner and Mullins. So now I've said, assume then that you're acting for the mediator, you're acting for Peter, that instead of acting for Peter, you're acting for you are the mediator conducting the mediation. And in private session, Peter and his lawyers, Peter tells you that he has a bit of cancer. What should you, as the mediator, do about that? Do you have a duty to do anything at all with it? Any thoughts? Well, first of all, presumably there's, I think we had the mediation agreement, which says that the mediator will preserve total confidentiality in the mediation and in relation to any exchanges that may come to his knowledge. So the mediator has an obligation of confidentiality set out in the mediation agreement. He has a duty to act honestly and to correct misleading statements. So once you tell the mediator that, he will have a duty to tell the other side, in my view, because he will have an obligation to correct what has been said if it is in fact wrong. But I guess it depends to some extent on what the extent to which he's told about the cancer facts. In this circumstance, he's just told, look, I've got a bit of cancer. Well, I mean, that could mean a skin cancer that can be removed next week without any problems. If the mediator is not told any more than that, then maybe it won't be seen to affect what's done. But if he's told all of the cancer facts in this problem, then probably the mediator would have an obligation to correct what was said. And the final question, just to finish, is that assume that the parties are in a joint session and Peter's solicitor tells the insurance solicitor that the schedule of damages provided to the insurer details the cost of Peter's future care and says it's based on Peter's needs for the next 27 years. If you're the mediator and you hear that, what do you do?
Can I ask you a question, Anna? If there's a bit of cancer and you're the mediator, are you bound to try to flesh that out and find out exactly what it means? Or do you just let it go as a bit of cancer?
Well, I think you could ask the question, but depending on what the client was prepared, the client might say, look, I don't know. I haven't, because I think in this instance, he hasn't got any reports. There's no medical reports yet received. So the client really doesn't know in this instance the extent of the cancer he's got. He knows he's got a secondary, but he really can't confirm it, and maybe that's part of the problem. The mediator can't really go and tell something to the other side because he doesn't know enough about it when he's told about a bit of cancer.
He would be able to say if it's a secondary cancer, that its lifespan is...
If he's told that by the plaintiff, yes, he should tell the other side. Yep.
In the scenario you presented where he's got the full facts, is the mediator under an obligation to disclose that to the other side, or should he, like the solicitor example, just withdraw and say, I can't continue?
There's different views about this, and I say that I did this problem with another group, and I had very heated discussion. One party really said, no, they have to withdraw, and someone else said, no, the mediator is under an obligation to tell the other side. I guess it depends on what approach you take as mediator, but my view is you probably, if you can't get instructions from the plaintiff, because you would need to pass all this with the plaintiff. If the plaintiff won't give you instructions, then maybe as mediator you would need to withdraw. But your first port of call is to try and say to the plaintiff, look, I'm under an obligation of confidentiality to you, but I also have a duty to correct misleading statements to the other side. You've put me in a very difficult position. I would like your authority to disclose this fact to the other side, and you'd have to see what you got. And if you didn't, you might have to say to the other side, look, if I don't get that authority, I'm going to have to withdraw. Does anyone else have a view about that? No? If the matter then proceeds to court and the judge asks you about the life expectancy and the table and how it's derived, how are you going to answer it? Well, it's probably, you can't mislead the court. That's the first point about this. You have to be honest with the court, and I don't think you'd get yourself in that position in the first place, but if you were, then you would have no duty but to tell the court the truth. I think if there was a problem, you'd have to get your client's instructions. If the client didn't agree, then there could be an issue about having to withdraw, but your ultimate duty is to the court. So they're the matters coming out of that. Does anyone have any questions about anything that we've covered this morning? If not, I'll finish up. Thanks.
And on behalf of everyone, Anna, I would like to thank you for a very thorough and interesting presentation. And I guess they're issues which, for most litigation lawyers, can arise almost on a daily basis. So it's very relevant stuff, and I think we've had an excellent presentation from a very good presenter. Hannah, thank you very much from all of us.